Hello everybody, welcome back to the Praetorian. Before I get started, I'd like to start off with my usual introductory statement. Thank everybody for listening, and we appreciate all the likes, the subscribes, and we would also appreciate it if you could share these posts. The reason why it's so important to share these posts is because the Praetorian is 100% organic reach. That means that we do not pay for boosts, we do not pay for subscribers or likes. This is 100% organic, and we take pride in that. We wish to bring information to people with as little money involved, make it as free and cheap as possible for everybody. We don't support Patreon and people having to pay for any kind of information in the media that most of the supposed alternative media sources claim that they believe in. So by doing this, we believe that it's actually working on the problem when it comes to internet alternative media, and it's not hiding our heads in the sand. So that's why we do this. So if you could please like, subscribe, and share, we would greatly appreciate it. With all that said, let's continue with the topic. Thank you. Discretionary jurisdiction. The Supreme Court holds discretionary jurisdiction, meaning that it does not have to hear every case that is brought to it. Discretionary jurisdiction is a circumstance where a court has the power to decide whether to hear a particular case brought before it. Most courts have no such power and must entertain any case properly filed, so long as the court has subject matter jurisdiction over the question of law which must be decided, and personal jurisdiction over the parties of the case. Typically, the highest court in the state or country will have discretionary jurisdiction. The reason for this is that appellate courts in common law countries have two basic functions: error correction and ensuring the orderly development of case law. In the first case, the appellate court simply examines the record and determines whether the lower court applied existing laws correctly. In reverse, and sends the case back for severe errors. That is, the parties may generally agree on the applicable law, but the appellate will contend that the trial court incorrectly interpreted and applied the existing law. In the second case, the appellate court rules on novel issues in a case, and under the stare decisis, those rulings become new law in themselves. In those cases, the parties disagree vigorously if an existing legal rule even applies to the facts of the case, or the appellate may be deliberately trying to attack an established rule in the hope that the appellate court will overturn a prior decision and establish a new rule, where the question has been ruled upon by multiple intermediate appellate courts, and it's so perplexing that all the lower courts disagree with each other. An appellate court with discretionary jurisdiction is able to delegate error correction to lower courts, while it focuses its limited resources on developing case law property. In the latter situation, the appellate court will focus on truly novel questions or revisiting older legal rules that are now clearly obsolete or unconstitutional. For example, the United States Supreme Court hears cases by a writ of certiorari essentially meaning that it calls appellants up to the court only if their case is important enough to merit the resources of the court. The Supreme Court employs a rule of 4, meaning that 4 justices have to think the case is important enough to hear before the court will grant it review. Many state Supreme Courts use a similar process to choose which cases they will hear. Alright, we have come to the end of our 15 minutes, so I'm going to stop here and I will get back to this later on at a better time. I would like to say again, thank you for listening and have a good night. Have a good day.